Good morning, everybody in California or on Pacific time. Good afternoon to some places that you guys are watching from. Thanks for joining us again. It's another Tuesday, a beautiful day here in Sacramento. I wish we had some rain, but that might be over for the year. Today we're gonna be talking about bankruptcy. In our LA seminar, there seemed to be a lot of concern, a lot of questions. The bankruptcy topic was a hot one. And so Sabrina thought that it would be a great idea if we covered a little bit more of that. And then we did have a few questions come up since that about bankruptcy. And so Sabrina is going to visit us today. She's going to cover this Livecast this morning. So please, for those of you that know Sabrina, say hi. For those of you that don't, this is Sabrina Allen. Sabrina is our Executive Vice President of Asset Management. If you don't know her, she's a nationally renowned speaker, probably the foremost authority on workouts in the United States for these delinquent notes. And she is a wealth of knowledge about bankruptcy. Before we get started, I will do a disclaimer. Neither Sabrina nor I are attorneys, although I think Sabrina may have stayed in a Holiday Inn Express at one time or another. But we're not giving you legal information. We're giving you information based upon our experience. If you need further knowledge about bankruptcy, please contact a local attorney. Although bankruptcy, it's kind of it's good that it is a federal situation. And so if you know bankruptcy law in your state, you probably know most of it for the federal. And so you can do this from just about any place. Because the bankruptcy law is pretty similar from state to state. So Sabrina, thanks for joining us this morning, and feel free to take this anywhere you want, and let's discuss bankruptcy. So here you go.
Good morning, everyone. I'm happy that you have joined us on our livecast today. One of the things that I want to talk about, since Ron spoke about bankruptcy being federal, well, you know, Florida feels like they don't have to follow rules. In the 11th district, we see a lot of trend in Florida on cram downs or lien stripping in our second lien position, and it has caused lots of buzz in the industry, where Bank of America has decided to challenge the decision and the ruling of a judge in Florida about lien stripping on a second mortgage. So that ruling won't come until I think June 24th. I could be wrong on the date. But if this does not go in the favor of Bank of America, it could change the way we do business in the note space in second position. Because right now, we see a trend in the 11th district in lien stripping. That is Florida, Georgia, and Alabama. But most recently, we also see lien strip potential and petitions for liens to be stripped in second position in the state of Maryland. So somebody's jumping on the bandwagon to say, if Florida can get away with it, anybody can. And this is not something that has been allowed in some of the other districts. They're treating in Florida in the 11th district, Georgia and Alabama, and now Maryland, that second liens are being stripped regardless if they have been backed or secured by an asset because of the mortgage crisis and the values in the properties. So we're going to hope for the best when the decision comes out for the ruling in June with Bank of America.
Sabrina, can I make a comment or just to ask you a question? First of all, maybe there's some people on here that are not familiar with lien stripping, that you could explain what lien stripping means. And then once you do that, I have another question for you, okay?
So a lien strip is actually, we have a second mortgage, and because there's no equity, meaning that there is not a dollar above the value in equity in the property, that the second mortgage can be eliminated. And in a Chapter 13 bankruptcy, we as creditors are treated as an unsecured lien and generally walk away with no money. There's a couple of benefits to that. If you want to look at it, benefits. Most borrowers cannot complete their Chapter 13. So until they complete their plan, even though that there's been a motion approved for a lien strip, you're not actually stripped until the borrower or the debtor has completed their Chapter 13 plan.
Okay. So a lien strip is simply, it simply means that the security that supports the note is gone. It's an unsecured note now. The debt still remains, but the security behind it is gone, and we cannot foreclose. The second point is that you made, I think, is very, very important, because I can see right now, after what you said, a bunch of people shivering in their seats saying, oh my God, seconds, and they're going to allow them to strip them. Please keep in mind that, first of all, the borrower needs to file bankruptcy before there's a lien strip. Secondly, there has to be no equity. $1 of equity prevents that lien strip. And I have been told, and I'd like you to confirm whether if you have the same information or not, that less than 10% of the bankruptcy, or the bankrupt petitioner, the borrower that declares bankruptcy in a Chapter 13, less than 10% actually complete the bankruptcy. So if there's, let's say that half the people declare bankruptcy, I think that's a huge number. It's not an accurate number. I'm just using it for example. And only 10% of the people that file actually complete it, then less than 5% would actually get lien stripped, and less than that would actually have absolutely no equity. So it's not something that the sky is falling, but it's something that you need to be aware of. And do you have any other information about that, or have you heard the same numbers, that less than 10%?
That is correct. You're correct with the numbers. And the other thing that you also have to keep in mind, because of the bankruptcy laws changing, whether it be a 7 or a 13, there are some income guidelines for a Chapter 13 and a Chapter 7. So if the borrower or the consumer or the debtor does not meet those guidelines financially, they can't file bankruptcy. So that's another thing that you can look at as a positive when you're doing your assessment on the risk of bankruptcy on your pool of loans you're purchasing.
Great. Okay. Well, carry on.
Okay. So one of the things that after you find out that a borrower has filed a Chapter 13 bankruptcy, you need to file a proof of claim. And sometimes you'll see documentation such as a POC. So that's a proof of claim. I'm also going to touch on the transfer of claim. So if you've actually purchased a note, like one we just purchased yesterday, and there's already payments being paid in the bankruptcy, you need to file a transfer of claim. A lot of the districts now are requiring you to pay a $25 fee when you send in your transfer of claim. So your proof of claim is proof that you are a secured creditor and that you are entitled to collect money, and payments will be made to you from the trustee. Transfer of claim is actually an endorsement, or actually acknowledging that now that proof of claim that was filed needs to be transferred to you as the investor. And if you don't file your transfer of claim, you will not receive any payments. And sometimes they'll go to the previous seller of the note, and hopefully you have somebody that's honest that will forward you those payments. But you need to make sure that if you buy a note that's in an active bankruptcy, you need to make sure that you file a transfer of claim to make sure that you're collecting your payments, and also to receive any notices in reference to if the case has been dismissed, if there's been any motions, if there's been any changing, any change of the plan, of the bankruptcy plan, you're made aware because you actually have listed yourself as a creditor.
When you said if you would buy a note that was in active bankruptcy, so you would buy a note where the homeowner or the borrower had actually declared bankruptcy?
Absolutely.
Okay, well, I'm glad to hear that. We're going to talk about that later this morning. But so where would people go to get any information about that particular bankruptcy?
They would actually go to Pacer. I think it's pacer.com. And basically you can sign up. The fee is minimum. You're not charged unless you use it. There's no membership, but you should join Pacer. Or if you're not computer savvy, because some of us are not, there is.
You're talking about me there, aren't you?
No, I was not, because
okay.
Every time I make an old joke, you get mad. So no, I wasn't talking about you. But if you're not computer savvy and you just want to know, and you know the district that they possibly filed in, and you know the borrower's social security number, there is a voice activated system that you can dial into, and you can find that online, and you can download every single district's number to actually dial in to verify if a borrower has filed bankruptcy, and you'll get their case number, the status of the case, and what district it was filed in.
Okay, good. All right, carry on.
One of the other things is that we talked about people just being fearful of bankruptcy, and they don't want to deal with bankrupt notes. And I really feel like that bankrupt notes are the diamonds in the rough if you actually play your cards right. If you pay the right price on a loan, whether it be a 7 or a 13, there is value in buying bankrupt notes. And some of those values is that sometimes a borrower has filed bankruptcy in a Chapter 7 per se because they're trying to get rid of all of their unsecured debt, I'm sorry. So they're trying to get rid of medical bills, they're trying to get rid of credit cards, they're trying to get rid of things that they just don't know what to do with, and they can't afford to pay their bills and their mortgage. So sometimes if they file a Chapter 7, they'll sign a reaffirmation agreement where they're still willing to pay their lien holders on their mortgage. That's a home run all day long. But you need to understand that still pricing is an issue because you have to wait. There's going to be a time frame that you're going to have to wait. And then also, if they file a Chapter 7, you can't communicate with them in reference to pursuing them to pay the debt. So my backdoor procedure is that we actually contact the borrower's bankruptcy attorney to see what their intentions were, if they were intending to surrender the property, if they wanted to continue to pay. And sometimes you'll find a borrower will file a Chapter 7 and continue to make payments on their mortgage while they're going through the bankruptcy because it's never their intention to walk away from their home. But most attorneys are very, very open to allowing you to call their borrowers every now and then. I'm not their borrowers, but their clients. But sometimes you will get a hold of an attorney who basically the bankruptcy's closed. Don't call my client. No, you can't reach them. So then you have to initiate foreclosure, but that's not a bad thing because generally when they get that letter from an attorney, what does the borrower do? They initiate communication with you to say, how can we work this out? So it's just a matter of preparing yourself to knowing that you're going to see a return on your investment, but it may be longer than what you want. But sometimes that's a lot faster than going through a foreclosure in the state of Florida because the state of Florida, New York, New Jersey, there are very long foreclosure states. So keep that in mind also. Okay.
One point that it just came to my mind when you were talking there, I think our experience, and I'd like to address this from your experience because you're far more experienced than I am in the workout process, but we oftentimes shock a bankruptcy attorney on what we're willing to do, which is far better than what the trustee would ever do as far as doing a workout. For example, let's say that a borrower's payment was $500 a month and we're willing to take $3 when the trustee is willing to take the $500 payment plus arrears. So now they're paying $800 a month when we would have allowed them to pay $300. And the attorney usually is absolutely shocked because they're normally dealing with a bank who says the only way out of this is to either become completely current or pay the debt off, or we're going to foreclose. What's your experience there?
My experience has been the same, and sometimes the attorneys just are really amazed on how flexible we're willing to be. But that's the value of becoming the bank. You can embrace homeowners in situations that traditional banks just can't do because they're held to a higher standard. And we still make money on actually accepting a lower payment. It's just a win-win for us and the homeowner. And that's really funny because, you know, a lot of times if we send a demand letter, you'll see a borrower go fly to an attorney and they've paid attorney fees that could have come to us. And all they really had to do was pick up the phone and communicate with us. And then the attorney, you know, when you start engaging with the attorney and start talking to them, you find that they're just in awe on what we're willing to offer. And it's realistic, a realistic resolution to the borrower, and they didn't even have to go through the process that they went through.
Great. Okay. Can you elaborate a little bit about the different kinds of bankruptcies there are? Tell the people what the difference between a 7 and a 13 is, and so that they kind of understand the difference there.
A Chapter 7 is basically you're putting all of your debt in, and like I stated, you can reaffirm anything that's secured, such as a car or a home, but basically you're discharged from the debt and you're not ordered to pay that debt. You're not held in a contractual agreement to repay any of that debt. There's no restructure. And in a Chapter 13, before I go to the 13, I want to back up too. So in a Chapter 7, there's 2 courses that a consumer has to take. I think that's the same course, but it's basically a consumer credit counseling course that they have to complete to basically see if their thinking's any different at the beginning versus the end. If they don't complete that consumer credit counseling course that they have to pay for, and they have to do it with either a counselor or online, they never get a discharge from their bankruptcy. So that's something that's been put in place to make sure that the consumer does not end up in the same place that they were in before they had to file bankruptcy. So that's what a Chapter 7 is. And a Chapter 13 is reorganization of debt. So basically, you can either pay or address your arrearages inside or outside the plan of your restructure of your debt. And there is payments that's required to be made on a monthly basis in a Chapter 13. If they do not make those payments on time and they don't comply with the order or the instructions that they've agreed to and the trustee has agreed to, their bankruptcy can be dismissed. And when it's dismissed, basically they start over, and basically nothing really has changed for us as the bank, other than the fact that we had to wait to watch them fumble and fall. And again, it can still be a win in a Chapter 13 when we reach out to the borrower or possibly reach out to their bankruptcy attorney to say, hey, we're willing to work with your client. So that's the difference, crash course on what a 7 is versus a 13. And there are huge guidelines with the Chapter 7. So if you're making a boatload of money, you're not going to be able to file a Chapter 7 as easily as you could 5 years ago.
Okay, great point. A Chapter 13 borrower that enters Chapter 13, a trustee takes a look at all of their income and says, okay, we're going to try to pay off your creditors, whether they are secured or unsecured, correct? I mean, if they're secured, they come first, but anything left over is going to be paid to the unsecured creditors, which, if there is a lien strip, and the reason I'm asking this, Sabrina, is because it has happened, where we had a lien strip, we were willing when we started to take a workout payment from the homeowner that was about 50% of what they had been paying in the past. And the trustee, because it was now unsecured, set up a payment that even on the lien stripped unsecured debt, we were getting more than we were willing to take on the workout that we were willing to do before they declared bankruptcy. So I think a lot of people hear about Chapter 11s, which is basically it's the same thing as a 13, only it's for a business or with people that have assets of over $1 million can also, but that's where the trustee, who's pretty much charged with your bankruptcy, sets up a payment schedule to pay your creditors off with the income that you have. Is that correct?
That is correct.
Okay. All right. So,
Ron,
yeah.
one of the things that I also want to take I want you to take into consideration or address also. So in a Chapter 13, you see the schedules. Sometimes you'll see retirement accounts sitting on those schedules. And if the bankruptcy is dismissed, that's a way for you to go in and actually request the down payment because foreclosure is considered a hardship, and we're able to actually draw on some of that money. Not all the time, but sometimes that's a good way to look at maybe another way to actually get money from the borrower if their bankruptcy is dismissed from their retirement accounts. Depending on their employer, some of them, I think a lot of school teachers or government agencies don't allow them to tap in even for foreclosure, but it's on a case-by-case basis. And depending on the school district or the state on if they can actually tap into that money. But it would be on the schedules when they're looking over the schedules in PACER. Okay.
A question just came in, Sabrina. You may have answered it already, but are there any states right now that can strip a Chapter 7 other than Florida? Kathleen Wynn asked that question.
I think I just saw a case in Maryland.
Okay.
But I don't know. I don't know the outcome. There hasn't been a definite. But that's again Florida breaking the rules in that 11th district, thinking they're above the law.
Well, we have a District 9 out here too. It's maybe even worse than District 11, but District 9 is the most overturned court in the country. I would like to make one point that I think is it's important to me, and that is that should this ruling by the Supreme Court say, yes, it's okay to strip the lien, we're really in no different position than we are right now as second holders. Right now, they've been able to strip the lien, and we've been living with that. And really not impacted that greatly by that because number one, we still have an unsecured debt. And number two, there's so few that actually complete their bankruptcy that it really doesn't matter. If the ruling goes the other way, where Bank of America wins this case, and my feeling is banks run this country. If they didn't, they wouldn't be in charge of cleaning up their own mess that they created. If they win, that puts us in a stronger position because now all of a sudden the lien stripping is not an acceptable practice anymore. So I'm afraid people will get overly concerned about this lien stripping when really it's not that big a deal for them if it happens. So, okay. So any other question come in yet, Mark? Okay. All right. Go ahead, Sabrina. Carry on.
What I want to say is that in the note space, this is an investment. And in any investment, there are risks. Do you panic with your money sitting in the stock market? Well, you should if you don't, because you're in less control. But if you are buying just a one-off in reference to this, and this is the note that you've purchased and you've used your last bit of savings, then it would be a concern. But if you spread your risk by making an initial investment and you buy a pool of loans, it minimizes your risk on something happening. There are going to be good loans, there are going to be bad loans, whether they're bankrupt loans or they're not bankrupt loans. You just have to understand as a note investor that there are risks, but all of this that's going on with Bank of America in the bankruptcy court, if they win, this will be huge. It will be a big home run for us. But even if they lose, it doesn't mean that it's the end of the note space. It doesn't mean that we won't be able to do business. It won't mean that we won't be able to operate business as usual. So you have to think about the positives and all of the upside and money that's to be made in notes. Just make sure that you are being wise on your due diligence before you make a purchase or you invest in notes. That's where you have to make sure that you're protecting yourself.
That was a great statement there. So to recap, number one, you need to follow your notes to see if bankruptcy is filed by your debtor, because you cannot communicate with them after they declare bankruptcy. You don't want to make phone calls or send letters to people that are in bankruptcy. You're not allowed to do that. So the only way you would know that is to check with Pacer or check with on the telephone line to make sure that your borrower has not filed bankruptcy. The second thing is if they have, you need a proof of claim. If you buy a note where there is a bankruptcy already, you need a transfer of claim, correct?
Correct.
And you need to make sure that you have an assignment recorded, correct? That
Correct.
In order for you to file a proof of claim, you need to show that you have an assignment recorded that shows that you bought that trust deed or mortgage, whatever it was. Okay, so we're going to go one step farther in this. We're going to talk about, I'd like to bring up two things. First is that what you said about the risk involved is that we for example had somebody call this week that wanted to get into the note business, and they had $20,000. And quite honestly, we have to advise them that that's probably this is not an appropriate investment for $20,000, because let's say you were able to buy 2 seconds with that, you could get the 2 worst seconds in the world just by the luck of the draw. And in this world of note investing, you need to spread your risk. You need to spread your risk over a fair number of notes, and maybe 10 or whatever. So I'm not giving you investment advice, but at the same time, I want to be sure that you understand the risks involved, and you don't just go out and buy 1 second. And the second thing is that it just was very timely when we decided to talk about bankruptcy, is because yesterday we got a call and I bought a note, and I'll give the people that are watching the parameters of this note, and then I'd like you to discuss the status, the situation, and the value and so on. So we are not afraid of bankrupt notes. In fact, we would entertain a tape of all bankrupt notes. It is a matter of how much do you pay for it. So this one came in yesterday. This is a Florida note. Florida judiciary state, takes a long time to foreclose, although we have an excellent attorney in Florida. An excellent attorney in Florida that Sabrina has firsthand knowledge and very well acquainted with. The note had original balance of $83,500. It currently has an unpaid balance of $79,000. The original interest rate, 7.5%, was originally written in November 1st of 2009. The term was 30 years or 360 months. The homeowner paid for 60 months, 5 years, and then went delinquent. So there's 300 months left on the note. The original payment amount was $600 a month. She declared Chapter 13, and the trustee set up a payment schedule for her to pay us, or to pay the seller of this note, $950 a month, $600 for the original mortgage payment, and $350 additional per month to pay for the arrears that she was now in because she hadn't made a payment for 6 months or so. Those go on for 36 months. She has paid 3 of them already, so there's 33 months of those left. And the fair market value, clear capital appraisal, $100,000. So Sabrina, kind of give us your expert input on that note.
Well, that was a home run, is what that was, as I was sitting here making my own notes as you were talking. I think I was aware of this, but I just wanted to make sure that I was, doing some math right. So the fair market value, I just want to point something out to you. Right now, the current unpaid principal balance is roughly $79,000. And the fair market value of this property is $100,000. So right there, we have equity in a note that we don't always see in our world. So that's home run number one. The terms of the loan, the interest rate, 7.5%, is a decent interest rate. If the borrower had called us on this particular loan, I probably would have even agreed to take this interest rate down to 5% and saved her some attorney fees, where she never would have had to file a Chapter 13. And she definitely wouldn't have been in a worse situation making monthly payments. I feel like the trustee is setting her up for failure. If she's already fallen behind, unless there was some type of a temporary hardship, she'll never be successful in completing this plan of $600 on a monthly basis for the current payment and $350 for the arrearages. It's just not possible if she was already struggling. The value is that she has made 3 payments. If she doesn't make the payments and she's dismissed from her bankruptcy, we have a great attorney in Florida that we can refer this file to, and has found ways to cut corners on foreclosure where we won't wait maybe as long as a lot of other people do if we have to initiate foreclosure. But whether this loan was in bankruptcy or not, I feel like it was a home run based off of just the circumstances in the note, where there's equity in the property above the first, so we're secured there. And to me, it's a home run, and I would have paid up to probably 45 to 47 cents on value on this note.
On fair market value, 47 cents of fair market value. Good. We paid $31,000 for this note, and you and I discussed what our intentions would be with something like this. If this lady falls out of bankruptcy, which we expect that she will, because we bought this at $31,000, we would do a workout plan with her to probably reduce her interest rate and to actually reduce the amount of monthly payment that she made, and probably extend the time back to 360 months. But our goal would be to keep her in the house. Now, let's assume that she does fall out of bankruptcy. We call her back and say that we would be willing to take $500 a month to keep her in the house. That $500 a month is $6,000 a year on a $31,000 purchase price, would return us about 20% annualized. And that would go on for 360 months or 30 years. So whether we would keep that for cash flow or whether we would sell it to an investor for a 10% yield to them remains to be seen over what happens to it. But the only reason that Sabrina and I brought this up is to tell you that bankruptcy is not something to be terrified about. That if it happens, and it's rare that a 13 will go through, the ability is still there for you to make money on the note. In fact, you can buy bankrupt notes like this first, but we buy bankrupt seconds. It's just a matter of what are you willing to pay for it. And if you pay a fair price, you're going to make some money on it. So one more question came in, and this was in a chapter 13. It takes longer to complete the plan, but in chapter 7, is it much faster? And will it be more successful for the borrower? That's kind of a hard question because I think it's two different kinds of borrowers that declare chapter 7 versus chapter 13. The person that declares chapter 7, just they just don't have any possibility of paying off their debts, no matter what the plan is. They just want to walk away from it. And what do you think, Sabrina? The choice between a 7 and a 13 isn't made because
so one of the things is that they also wanted to know about time. So a chapter 7 generally takes about 6 months. And we already stated that, you know, we see chapter 13s could be 36 months or 60 months. I think that's the months, if I'm thinking right. So a chapter 13 can go on for a long period of time. And there's two different types of borrowers who file, as you stated, Ron. A chapter 7 borrower, basically they don't have any assets, they have very little income, and they just really don't know what to do. So they file bankruptcy, and it's basically an uneducated consumer that does that. A chapter 13, you find a more sophisticated consumer who has some assets, who has some money, who has more of a career background, who's established, but just is in over their head. Both of them are in over their head, but on a different level. And not insulting one consumer versus the other, but it's just basically what we've seen over the years in the industry.
Great. Well, I hope this was informative to everybody. Bankruptcy is just a part of life in this business. It happens every day. I've been in several different businesses where bankruptcy impacted our business, and in most of those businesses it impacted it in far greater ways than it impacts it in this one. But again, thank you, Sabrina. The next time that Sabrina comes on, probably not next week, but the following week, we're going to talk about foreclosure and what to do after foreclosure, as well as pre-foreclosure, judiciary versus non-judiciary, and we'll cover that pretty thoroughly. If you have questions on that, please get them into us before. And I guess it's a good opportunity to tell you about the seminar boot camp that's coming up in San Francisco in July. We've reduced it down to 3 days from 4. 4 was just way too intense for the participants, as well as us, Sabrina and I, and Tyler and Chrissy. 4 days was just an overload. We're going to cover the same material in 3. We'll just go a little later every day. Sabrina will be there with all of her knowledge and chance to ask her questions. Go to notemogul.com, notemogul.com, if you want to learn about the boot camp. Sabrina, thank you very much, and enjoy the spring in Ohio. Take care.
Will do. Okay,
all right.
bye-bye.
Thank you.